Hello, everyone, and welcome to today's webinar. My name is Avi Friedman, and in today's webinar, this is our annual travel webinar, and we'll be doing our 2022 consular holiday update. And so just to start off with, we've got our legal disclaimer that nothing in this presentation does not constitute any type of legal advice. This is just for informational purposes only. And if you do have anything case specific or need a legal opinion, it's best to schedule a consultation with myself or one of our other attorneys on staff. So just real quickly, an overview about our firm, WR Immigration. We're one of the top rated immigration law firms. We provide strategic client-centered services and very tech-focused and work with both individual and corporations as well. A little bit about myself. I've been with the firm now about 25 years. I went to Loyola Law School, and for undergraduate, I went to UCLA, a couple of accolades there. A little bit in terms of my experience, for many years, I had traveled both north and south of the border, meaning to Mexico and Canada, as well as other countries, to visit U.S. consular posts along with many clients, probably over, many hundreds, over 1,000 visa applicants. And it used to be in Mexico and Canada that the attorney could actually represent the client, meaning go inside the U.S. embassy or consulate along with the visa applicant and represent them. So I have a unique sort of perspective on the visa interview process, and hope to share a little bit about that with you today. So in terms of our agenda and what we'll be covering, this is a really brief outline, but goes through our topics. And so we'll start off with a general anatomy of a visa interview. Then we'll talk about general considerations in applying for a visa, non-immigrant visa. Talk a bit about the aftermath of the pandemic. Talk about visa options outside of the normal place of visa application, meaning your home country. So talk third country national visa applications, or TCNs for short. We'll talk a little bit about the consequences of the Ukraine war, and then do a quick overview about administrative processing, what that means, and how that impacts the visa process. And then we'll spend some time taking questions, so you can use the Q&A function. At the end of the presentation, I will run through those questions and try to address as time permits. We won't be doing questions until the end, so you're welcome to post your question, but we'll look at it as we get toward the end of the presentation. So starting off with the visa interview, as you can see from the graphic here, this is what a typical visa interview process looks like. You have the consular officer who's behind the bulletproof glass window and the visa applicant on the other side. I think it's a bit unusual to be seated. Most of the time, the applicant is standing up and you're talking to the officer through that glass window. It's a really quick visa process for the most part. Consuls have hundreds of cases they have to get through in a typical day. So that only leaves them a couple minutes for the whole interview process. And during that interview process, many things are going on behind that window. The consular officer is reviewing the application. They're looking at their computer, reviewing the DS-160. They're conducting the verbal interview. They're conducting security checks, typing up their case notes, possibly looking at documents, and that's optional on the part of the visa officer. And they're reviewing if the applicant has to prove that they're not an intending immigrant, they're looking at what are their ties abroad. Consuls oftentimes feel that they are lied to because in many countries, fraud is quite common. Documents are made up. And so anytime an applicant gets caught in even a white lie, that's going to result in a visa denial. The bottom line is, in summary, that every time somebody appears for a U.S. visa interview, it's before a different consular officer, and their name is on the line when they issue the visa. So they have to be satisfied that the visa applicant qualifies for the visa in terms of all these things that we just discussed. And so even in a renewal context, you shouldn't take anything for granted. You have to treat it very seriously and be prepared, because it's not a given that the visa will be issued or the visa will be issued timely. In terms of the visa application itself, a couple of quick visa interview tips for visa applicants. Number one, be honest. You don't want to say anything that's not correct. Don't want to make any misrepresentations or commit fraud. Keep it short and simple because it is a quick interview. Consuls don't have time to hear long stories. They just want simple yes or no answers. They don't want to hear a long version. In terms of documents, from the visa applicant should be really organized in terms of their documents so that if the consul does ask for a document, the applicant can present that document right away. The consul usually gets pretty upset when it takes a long time for somebody, let's say, to find a bank statement or an approval notice or whatever the piece of information or documents that they ask for. It's very important to be on time for your visa interview, but not too early. If you arrive late, there's a chance they may reschedule your appointment. And it's very important to be very professional, both in your appearance. You don't want to dress up too casually. You want to treat it as a business interview, dress up nicely and professionally, and to be very nice, to be on your best behavior in terms of interacting with the consular officer, very polite, very respectful to the visa officer. Even if the visa officer isn't polite or respectful to the applicant, you can't get into a shouting match with the consular officer. You'll never end up winning. It's also important to review the list of prohibited items. For the most part, most U.S. consular posts do not allow in any electronic devices, no cell phones, no laptops, no electronic car key fobs, no food, no liquids, no big bags or briefcases, and of course, no weapons. I think there's a couple of exceptions throughout the world. I do believe the U.S. Embassy London allows in cell phones, but that's probably the exception to the norm. But it's important that you check the consular post website to see what's not permitted, because there could be delays and you could lose your appointment if you show up and you don't have a place to store your prohibited items. Now we're going to move on to preparing for international holiday travel. And on the next slide, we have a list of just general documents, how to avoid delays based on documents, what you should bring to a visa interview, or if traveling back to the United States, how to deal with Customs and Border Protection, what documents you need. Before we go into the details, just if possible, it's much easier said than done. Travel is starting to resume now. And people do want to travel to make up for lost time over the last couple of years. But because of delays and uncertainty, of course, if possible, it's best to avoid international travel. But if you do have to travel, be prepared for delays and try to anticipate how to prepare for visa interviews or reentry. At a minimum, you definitely need to have a valid passport. That passport should be valid for at least 6 months beyond your intended return back to the United States. And if you're applying for a visa, you should have at least several blank pages for the issuance of the visa, just in case they make a mistake on the visa and have to reissue. If you only have one clean page left, then it's going to be a problem while you have to renew your passport. So always give yourself at least a couple of completely blank pages on your passport. If you plan on returning back to the United States, for the most part, you will need to have a valid U.S. visa to be able to return. There are some exceptions, for instance, for Canadians, and also for those that are trying to benefit from automatic revalidation. You should have your approval notices, the Form I-797, if it's a non-immigrant petition-based application, and a full copy of what was filed with the Immigration Service. If applying for a U.S. visa, you should have evidence of your maintenance of status in the United States. So, for instance, an updated current employment verification letter, recent payroll records, tax returns, etc. If it's a family relationship, if you're a dependent, you should have the birth or the marriage certificate. If you're pending adjustment of status, you definitely, to be able to return, for the most part, you will need to have a valid advance parole. That's unless you have a valid H-1B. or H4 or L1 or L2 visa. And if you're a U.S. permanent resident, then you should have your valid green card to be able to travel back. There's delays across the board, and the key is just plan ahead and be ready for potential delays. From the visa interview perspective, some of the minimums that you will need, in addition to what we talked about, is the DS-160 barcode confirmation page. You want to bring a recent color passport photo that complies with Department of State requirements that should be taken within a few weeks of your visa interview. I was just at the U.S. consulate in Vancouver last week and with a client, and did notice, people were getting turned away because their passport photos didn't meet the requirements and they had to scramble to get their photos done. So do check Department of State online. They have the exact measurements, and you want to make sure that your photo matches what's required. You want to have the proof of payment of your visa fee and also a copy of your appointment notice to be able to show to the clerks outside the consular post and security as well. Important to check the Department of State website and individual consular webpage for very specifics, because local requirements vary throughout the world. And here we have the link, usembassy.gov. You can click that link and check. Every U.S. consular post throughout the world is on there, and you can see what's required from the visa perspective. Again, the word of advice is be ready for delays and try to plan as far in advance as possible. Lastly, on our last slide here about the documents, originals are very important. So, of course, your current passport and any prior passports that contain U.S. visas or admission stamps. It's preferable that you bring the original of approval notices, or if you're a student, an I-20, or if you're an exchange visitor, the DS-2019s. And if you've ever lost a passport, it's important to file a police report as soon as possible and bring those documents with you, because consuls always get concerned about lost passports. If you've ever had any issues with the police, meaning arrests or convictions, consular officers want to see and require certified copies of the incident, not just photocopies, but actual certified copies from the courts. If you're married and your dependents are applying either with you or without you, they need to bring their original, their birth certificate, or in a marriage situation, the marriage certificate. And if it's not in English, likely best to have it translated to English. And if you have a degree, you should bring originals of diplomas and transcripts. I have seen consular officers insist that they see the original degree, even if it's in a frame. You got to bring that with you to the interview if they insist upon that. So now we'll move on and talk about the aftermath of the pandemic, COVID-19, and how that impacted the visa world. And so during the past administration, during the Trump administration, approximately 40% of consular officers were either terminated or they ended up resigning from their positions. And so that left a lot of consular posts not manned properly. They didn't have the proper staffing, plus local staff, because of local country conditions in the pandemic, weren't able to get to their offices. And so that created huge backlogs at consular posts for visa interviews and for processing. So the good news is that Department of State has gone on a hiring spree, but likely it'll take another year or so until we see the full impact. Here, these next bullets are some interesting statistics that Department of State has recently provided, showing that most of the consular posts throughout the world have resumed visa operations. Department of State is proud to announce that they've lowered visa interview wait times worldwide following the closures during the pandemic. They've doubled the hiring of U.S. Foreign Service personnel. Their statistic is that 96% of consular posts are again interviewing visa applicants. The non-immigrant visa application rate is at 94% of pre-pandemic monthly averages, and they are at 130% from the immigrant visa perspective, although there's still huge backlogs. And in the past 12 months, they've processed, going back from September 30 of this year, they processed 8 million non-immigrant visas during that year. And the Department of State does estimate that approximately 30% of non-immigrant visa applicants may qualify for an interview waiver. And so that frees up space for them to conduct interviews for those that do require in-person interviews. So what we are seeing mostly around the world is what I would say a slow return to normal processing. We're still seeing some really heavy backlogs impacting appointment availability at some of the major consular posts that handle many visa interviews. I think the top 3 visa issuing consular posts in the world are Mexico, India, and Brazil, and they still have very long backlogs, especially for visitor visa applicants. Mexico, you could be looking at anywhere from 1.5 years to 2.5 years to get a regular B1, B2 visitor visa appointment. And even in the work visa categories, you're looking at least several months of a backlog before you can get an appointment. So there still are significant wait times, backlogs, and appointments still do get canceled. When you go online to schedule after you've paid your visa fee, completed the DS-160, if you find that there's no appointment availability, it's critical just to keep checking back, whether it's every hour, every couple of days, because appointments do get released every so often online. And so you can always go online and check just to find the first available appointment. Cancellations happen and those get re-released into the appointment system. Once you've secured your appointment, and if you need an appointment sooner and you can qualify, you can always request an expedite, and the consul will review that. And if they need more information, they may send you instructions on how to upload or send the supporting documents in support of your expedite request. Every country, every part of the world has varying conditions because of the pandemic. And so while we would like to have a concrete time, there just is no definitive time as to when all the consular posts throughout the world will resume normal processing. It's really just a wait and see. But many posts are back at normal and some still have the backlogs. If you want to check visa wait times, you have the link here. Really good resource is the travel.state.gov website here. This link shows all the consular posts throughout the world. They provide updates as to typical wait times for visitor visa appointments, student visas, work visa categories. The important thing to remember is that these are approximate, and so they're not always accurate. And oftentimes you take a look at the appointment wait time thinking it's not too bad, and then once you go and pay the visa fee, the wait times tend to be a lot longer than what's posted here, so don't take it as concrete. Also, the posted wait times don't normally apply to third country national visa appointments. So TCN appointments typically are much further out than what you're going to see for those that are in country and applying. Couple points about third country national visa appointments and applications. From the Department of State's perspective, a visa applicant can apply for a non-immigrant visa in any country in which they are resident or physically present. So that's the rule. How it's enforced varies throughout the world, based on their local conditions and availability and staffing. And so historically, Mexico and Canada were set up to handle many third country national visa appointments. And what we noticed during the pandemic, as of late, Mexico has restricted it, and they only want applicants who are of Mexican citizenship or resident in Mexico. They really have restricted third country national visa appointments. Prior to the pandemic, they did accept renewals of same category visas, and many years ago, they would accept just about any type of visa application, whether it be first time or renewal. North of the border in Canada, they pretty much will accept any type of visa applicant because, as I mentioned, Canadians, for the most part, don't need U.S. visas in the non-immigrant visa context, except for the E-visa and the K-visa. So most of the applicants in Canada are going to be Canadian residents who are not Canadian citizens, or third country nationals who are coming to Canada to apply for the visa. And so the preference is given to those that are resident in Canada, and third country nationals are on a different calendar and tend to get appointments that are much further out. And appointment availability still is a big issue at the consular posts in Canada. In terms of vaccinations and testing, the good news is the current Biden administration, as soon as Biden came into office, he did ease a lot of the travel restrictions that we saw from the Trump administration. And so one of the first things that came through, which was great news, was that the geographic travel bans were rescinded. And the one thing instead that he implemented was, as of January, travelers to the United States who were not permanent residents or U.S. citizens had to show proof that they were vaccinated against COVID-19. And only vaccines that are approved or authorized by the FDA or listed for emergency use by WHO are accepted for travel to the U.S. And there's very limited exceptions of getting around the vaccination requirements. You can go onto the CDC website and see the list of what's accepted from a vaccination perspective. The other positive news is that as of the summer, this happened June 12th of this year, if you're traveling back to the United States by air, you no longer need to show a negative COVID-19 test result. So that applied across the board for non-immigrants, U.S. citizens, and permanent residents. So that's not required to show to the airlines anymore. So what are the consequences of the Ukraine war? Across Europe, many of the consular posts have had a lot of pressure in terms of appointment availability because, number one, we don't have any more U.S. consular posts in Russia that accept visa applicants. Plus, now there's no post in Ukraine. And so all the Russian and Ukrainian applicants are searching for consular posts and appointments, and that put a strain on any of the countries that border Russia or Ukraine in terms of visa appointments. In terms of proving non-immigrant intent under the 214B calculus, it makes it really difficult for a Ukrainian or Russian to be issued a visa from the consular officer's perspective, because Ukrainians are presumed to be refugees by consular officers, and Russians are presumed to be potential asylum seekers. And so if they're applying for a visitor visa or a student visa or an exchange visitor visa, the hurdle, the bar is much higher for Ukrainians and Russians than ever before. And so it's very important for Ukrainians and Russians to be even more prepared than normal for a visa interview, because there is a presumption on the part of a consular officer that they don't have the intention to return home after completing their trip to the United States. In terms of where you can apply as a third country national, technically we talked about the rule. You can apply anywhere that you're physically present. Sometimes the trick, though, is where can you actually find an appointment? So a couple of other points is that as of March of this year, Ukrainians were added to the State Department's list of homeless nationalities in the sense that they don't have a consular post. So if you're from Ukraine and you're looking for an appointment, it's really critical just to check the consular post website to see what the rule is in terms of third country national visa applicants, and then also check to see what are the visa and travel requirements, as oftentimes you may need a visa to enter the other country as well. So now we'll move on to talk about administrative processing and what that means. Administrative processing is this umbrella term that encompasses the various checks that consular officers conduct during that course of the couple-minute visa interview, as well as what may go on after the visa interview. And so starting off, it could be something as simple as what's called a 221G letter from the consular officer asking for additional documents. So let's say somebody forgot to bring in their I-20, or they forgot to bring in their SEVIS receipt, or they forgot their approval notice, something simple. the consular officer will issue this letter saying bring it in or submit it, upload it, and then we can move on your case. But that still constitutes administrative processing. It could be a fraud investigation. It could be an advisory opinion if it relates to a legal issue. And then we have SAOs, which are security advisory opinions. And so SAOs are the ones that tend to take the most time because it takes various vetting, not just from Department of State, but other government agencies as well. And so, when an SAO is conducted, the consul's looking at various things. One, does the person's activity in the U.S. going to pose a security risk? Are they involved in sensitive technologies? That's the Mantis security clearance. Do they have a common name? So for instance, Muhammad Ali is a very common name and very likely gets subject to what's called a donkey clearance. If you're from a certain country, such as China, Israel, Iran, Syria, Russia, there are heightened security checks that consuls will send them off for. If somebody has any type of criminal history, an arrest, conviction, even if it didn't result in a conviction, it can result in a delay, as well as if somebody has a history of alcohol or drug abuse, there may be a request for records or sending out for a requirement that the person see a panel physician. And so in terms of the administrative processing, consuls won't tell you what type of check you're undergoing. They won't say we're subjecting you to a Mantis or a donkey or a criminal check. They'll just say this is administrative processing, and we'll get back to you once we complete the process. Now, the checks could take anywhere from a few days to complete to a few months, and sometimes years to resolve. And sometimes it's indefinite. Department of State, if they can, will sit on it, and they never get resolved. And so it really just depends on the type of security check that's being done. And, the more simple the check, the quicker it's going to be. This does count as a refusal. So this is under what's called 221G. And so it does have to be disclosed on subsequent visa applications and could impact your ability to travel under the visa waiver or ESTA. It's very difficult to expedite a administrative process or security check unless the applicant is high profile. Sometimes you can reach out for assistance from your local congressperson, but oftentimes it's not too helpful. And then finally, if the administrative processing is dragging on for too long, typically at least over 6 months, you can consider filing a mandamus lawsuit against Department of State. A little bit expensive to do, but it does get the Department of State to act. Doesn't necessarily mean they're going to approve or issue the visa, but you will get some sort of decision from Department of State if you proceed with a mandamus lawsuit. So finally, to wrap up, what is the role that I play or we play as immigration attorneys in this consular processing realm? It really boils down to several critical points. One is the form, which is the online DS-160. Having an attorney review it and give advice and feedback regarding the DS-160 can oftentimes be important, especially when there are some potential issues. But surprisingly, even with straightforward cases, I've reviewed many DS-160s over the years, applicants do miss things, and it's important that you be consistent with your category and your history on the DS-160, and oftentimes I find that there are mistakes on DS-160s, and that's the primary form that the consular officer is reviewing at the interview. And so if there's issues with that, that can lead to a difficult interview. We oftentimes will prepare a legal brief that applicants can present to the consular officer, just packaging up all the critical documents, making it concise and easy for the officer to review and process, really guiding a visa applicant through the process from preparing for the interview, covering strategies, procedures, going through a bit of a mock interview so that you understand the types of questions that are asked in a typical visa interview. Over the years, as I mentioned at the start, I have traveled and gone in person with clients to visa interviews. And sometimes, these days, oftentimes I can only get as far as security and check-in, but consuls know that I'm there and I'm available in case there's any issues that do come up during the course of an interview. So that's an option that we provide as well. As you can imagine, and as you probably saw during the pandemic, visa procedures, policies, issues, they were changing on a daily, if not, very hourly basis. It can change very quickly. And so having an attorney who's up to speed on the current policies can be helpful. In the unfortunate event that there's a visa denial, then we can try to help in dealing with the visa denial and see if it's possible to reapply and deal with the issues that came up in that prior visa interview. And then finally, in the event of administrative processing or a security check, following up with Department of State and the local consular post, and if necessary, assisting with a mandamus lawsuit as well. That is something that we can assist with too. So now we'll check the Q&A and see if we can deal with some of the questions. So let's take a look. So here's an interesting question. What's your opinion on language proficiency during non-immigrant visa interviews? If an applicant can't speak English, does that affect the visa decision? So normally, when somebody's applying for a visa, consular officers in countries where English is not the primary language get language training. And so, for instance, let's say they're in China, they're posted in China, they get Chinese language training, and so they should be proficient to be able to conduct an interview in the local language. And so, just because somebody doesn't speak English doesn't necessarily impact the visa interview, but it could impact the visa category. In a dependent situation, I don't think it should be an issue. If, let's say it's an H4 or L2 or whatever the visa dependent category is, the fact that the dependent doesn't speak English, I don't foresee that being an issue. Of course, it could be an issue if they're the primary applicant and English is required for their job. I have seen consuls ask, if you can't speak English fluently, how are you able to perform your job? I have seen this out of posts in Mexico where the applicant, let's say for a TN visa, had minimal English language abilities, but they might be an engineer, and so they don't necessarily need to speak English on the job, or many of their coworkers where they work speak Spanish. So it's a fair question that consuls could raise, and that's a good question. Moving on to the next question. This is regarding consular posts in Mexico, is that they do not accept applicants for third country nationals, very few exceptions. Have I heard of any widespread exceptions? My understanding is it's still the policy that at least what's posted on the official website for the consular posts in Mexico, that hasn't changed as of the last time I checked it. There are ways to cheat the system and claim that you're a resident of Mexico, which is not proper. And again, any misrepresentation made in the application or even on the online system can result in the loss of the appointment. So when somebody books an appointment that they don't qualify for, when a consul realizes it, they could cancel it out, and then the person is stuck in Mexico without a valid visa. So it's very risky. If you do have questions, you can always reach out to the local consular post. They all have email addresses or online inquiry forms where you can inquire to see if they might make an exception and accept a particular case. And that's what we've done with posts in Mexico. When we did have a third country national, I always would confirm to make sure that the consul is comfortable accepting that type of case. It's not a guarantee that they're going to issue the visa, but that it's proper for the person to be applying at that particular post. So here's a good question about administrative processing. If you were caught in administrative processing the first time, how likely is it that you'll be subject a second time? And it's really difficult to predict because, as I mentioned, consuls don't tell you the type of check that they're conducting. But if you have a very common name and you got subjected to a long delay the first time, my guess would be it's very likely that you're going to get subject to that same type of clearance a second time, because they just clear you during that visa application, and they have to do it every time. Years back, the chief consul based in Mexico City told me that every day at the embassy in Mexico City, they had somebody by the name of Maria Ruiz who would apply for a visa, and they had to subject them to a donkey clearance. It could be an elderly, person, 75, and they clearly knew this was not the bad guy in their system, but because the name that they had in their system had no other identifying information, it was just the name, they had to get the clearance from Washington, and Washington had to farm it out to different agencies. And so if you've got that common name, you sort of get caught in that trap of having to go through it. And there's also even a chance when you're coming through at the U.S. port of entry after your visa has been issued, that Customs and Border Protection could send you to secondary while they do their own checks as well. All right, we have a couple more questions before we wrap up. This one asks, do you report 221G administrative processing as a refusal on future visa applications, even if 221G is ultimately resolved and approved, or only if received full denial? So I would say if you got a 221G and ultimately, so let's say it was for documents and then the visa gets issued, I wouldn't count that as a refusal, on subsequent DS-160s since the visa got issued. But if while it's still pending and you're applying for something else, then yes, I would count that and disclose it. All right. Let's see here. So this is an interesting question. Is it possible to get more specific reasons, not the general immigrant intent, for previous denial under Section 214B by contacting consular posts? So it's a yes and no. Nothing prevents the visa applicant, or if they retain counsel, to reach out to a consular post. Unfortunately, most of the time you get these standard letters with it's just ticked off the various boxes, 214B, and then you get the standard blurb about what that means. And so when you do reach out, the majority of times the responses are not very helpful. It's pretty rare that you get anything very meaningful from consular officers. They don't really give you the specifics about what it is. And the reason they're able to be so secretive is that all the consular information, any of their notes, any of their procedures is protected under privacy. So if you file a Freedom of Information Act request against Department of State, you're going to get just about nothing back except whatever the visa applicant provided. So you can get your own DS-160 or in the immigrant context, the DS-260, or any other documents that you provided, but you'll have no access to whatever the consular notes are. So those are protected under statute, unfortunately. So oftentimes it is, sort of like bouncing a tennis ball against a brick wall. You don't get very much back except, whatever you provided. So, all right. So those were really good questions. We're going to conclude today's webinar. I wanted to thank everybody for attending. You have my contact information, avi@wolfsdorf.com. If there was any other questions or issues, or you feel you wanted to discuss your particular situation in further detail, feel free to reach out. You have a list here of all our offices throughout the United States, as well as our branch in Shanghai, China. And you have our website, wolfsdorf.com. I do encourage all who are not currently on our mailing list to sign up for our email mailing list. We do send up updates as they occur, and we also send out notices about our upcoming other webinars as well. Feel free to follow us on LinkedIn or on Twitter or Facebook. We do have pages for that. And once again, thanks for joining today's webinar, and wish everybody a safe and happy holiday season. And if you do travel, I hope this was helpful and wish you safe travels and safe return back to the U.S.